Welcome back to The Explainer. Today, we are diving into a truly fascinating intersection of technology, international law, and a highly debated legal battle. We're going to be looking at this incredibly unique experiment detailed in our sources where artificial intelligence isn't just, generating text or writing code. It's actually being used to analyze domestic court rulings against global human rights standards. We'll be exploring the case of Dr. Chen Jingyuan, which serves as kind of the perfect testing ground for these AI models.
So here is our roadmap for today. We'll be covering Part 1, the Chen Jingyuan case. Part 2, the legal arguments. Part 3, the UDHR framework. Part 4, freedom of expression. Part 5, the right to a fair trial. And finally, Part 6, human dignity and equality.
Okay, Part 1, the Chen Jingyuan case. A retweet, an arrest, and a 20-month sentence. Before we get into the whole AI analysis side of things, we really need to understand the human element at the center of these source documents.
Now, the sequence of events for Dr. Chen was incredibly rapid. Just look at this timeline. According to the case documents, in September 2022, Dr. Chen, who is a researcher holding a PhD, by the way, was suddenly arrested at his home by police. Fast forward to January 2023, and prosecutors officially indicted him. By April, following a closed-door trial, he was sentenced to 20 months in prison. And then just a month later, in May, his appeal was rejected outright without even having a formal court hearing. It's a remarkably swift, definitive progression, and it's exactly what these AI models are going to scrutinize closely.
Moving right along to Part 2, the legal arguments, prosecution versus defense. To understand how the AI evaluated all of this, we first have to look at the exact charges.
It is absolutely crucial to understand the specific charge levied against Dr. Chen. He was indicted for picking quarrels and provoking trouble. The source material actually describes this as a pocket crime. Basically, it's a broad catch-all charge in the Chinese legal system that gives authorities a huge amount of flexibility in how they apply it, especially when it comes to online speech.
So in court, we have these two perfectly contrasting arguments. On one side, the prosecution argued that Dr. Chen completely ignored national laws and deliberately spread false info online, which they claimed caused serious public disorder. But on the flip side, the defense argued that Dr. Chen, acting as an independent scholar, merely retweeted and liked posts. And a lot of these were just political cartoons or opinions, stuff that doesn't exactly have a strict true or false standard, right? Plus, his account had fewer than 100 followers, mostly inactive ones. And they pointed out that there was absolutely zero quantitative proof that any public disorder actually happened.
Now, what's really fascinating here is the court's explicit reasoning for the conviction. Because direct evidence of malicious intent was so heavily debated, the court reasoned that Dr. Chen, being a fully capable individual with a high educational background, should be able to distinguish right from wrong. The ruling essentially took his PhD and framed it as evidence that he knowingly and intentionally spread falsehoods.
And this brings us to the core question of our explainer today. We're zooming out from this specific domestic legal battleground to a global perspective. When a domestic court uses this kind of reasoning, literally turning an academic background into a presumption of intent, how does that actually map on to universal, international agreements? And this matters to all of us, because how domestic laws interpret intent and evidence can have massive implications for everyday citizens living in our highly interconnected digital world.
Which leads us to Part 3. The UDHR framework and our 6 AI models analyzing the case. To answer that big global question, we're looking at a highly innovative experiment detailed in the source docs.
Researchers took the legal documents and fed them into a whole array of distinct AI models: ChatGPT, Copilot, DeepSeek, Gemini, Grok, and Qwen. Their analytical standard? The 1948 Universal Declaration of Human Rights, or UDHR. Now, the goal here wasn't to take political sides. It was simply to have these algorithms impartially map the trial's established facts directly against the globally recognized legal principles in the UDHR. Let's see what they actually concluded.
All right, Part 4, Freedom of Expression, looking at UDHR Articles 18 and 19. This is actually the first major theme where the AI models found a really strong consensus.
The models aligned really closely here as they broke down how Dr. Chen's actions were categorized. For instance, Grok noted a vital detail. Dr. Chen was retweeting posts from official sources, like a U.S. embassy account, over a VPN. Grok analyzed this as academic curation and information gathering, which it noted as protected expression, not criminal rumor-mongering. Then Quen chimed in, pointing out the inherent danger of equating differing viewpoints in artistic expression with rumors. And finally, ChatGPT stated plainly that criminalizing this behavior completely fails the international legal tests of necessity and proportionality.
DeepSeek also provided this really profound observation regarding the academic nature of the defendant. See, Dr. Chen had discussed complex scientific concepts like the CAP theorem online. DeepSeek observed that penalizing a researcher for exploring and discussing scientific and theoretical ideas essentially treats thought itself as a crime. It flagged this as a clear violation of the fundamental human right to seek and share knowledge.
Next up, Part 5, the right to a fair trial, UDHR Articles 10 and 11. Here, we're shifting from what was actually said online to how the trial itself was conducted.
The sources lay out three major procedural red flags that the AIs picked up on. First, it was a secret trial, completely closed to the public and even to the defendant's own relatives. Second, there was a stark denial of defense. During the trial, the judge reportedly ordered Dr. Chen to just shut up when he tried to defend himself using his technical expertise. And third, like we saw earlier, there was an apparent presumption of guilt, where the court used his academic background as proof of malicious intent, rather than relying on, well, objective evidence.
To highlight this evidence issue, we have to look at how Qwen AI analyzed the prosecution's technical claims. The police presented cached images found on an old mobile phone is ironclad proof that Dr. Chen was actively spreading illegal content, but Qwen's analysis points out a massive, almost unbelievable technical and legal flaw here. Finding an image in a web browser's cache only proves that a web page was loaded or browsed. It completely and wrongly equates passive browsing with active spreading and intentional distribution.
And that brings us to our final section, Part 6, Human Dignity and Equality, UDHR Articles 1 and 7. These concepts form the absolute bedrock of the Universal Declaration of Human Rights. So the crucial point here is contrasting the court's earlier stance on his education with this fundamental premise of the UDHR. All human beings are born free and equal in dignity and rights. Article 1 insists on the inherent dignity of all people. The AI models heavily evaluated whether the court's actions actually treated the defendant with this required level of dignity. While the consensus among the AIs was highly critical, Gemini noted that punishing a citizen specifically because of their high knowledge level is deeply anti-intellectual and demeaning. ChatGPT emphasized a profound philosophical point: state law must ultimately submit to human dignity, not the other way around. Furthermore, Qzin AI pointed out a severe issue of selective enforcement, which violates equality before the law. Think about it. While the original authors of the posts and large state media platforms that shared similar content were completely untouched, this solitary retweeter faced actual prison time.
Now, we must impartially note that the source documents also include Dr. Chen's own prison blood letter, which he wrote while incarcerated. In it, he levels some very heavy allegations against the authorities, claiming the existence of a judicial mafia and detailing instances of torture, like 24-hour interrogations and beatings to extract his passwords. AI models like Copilot and Grok framed these allegations, alongside the secret trial, as a systemic erosion of human dignity that starkly contrasts with the UDHR's strict prohibitions against degrading treatment.
So, to wrap up this explainer, we want to leave you with one final provocative thought. We've just seen 6 different AI models effortlessly dissect a complex domestic trial and map its procedures and evidence directly against an international human rights treaty. If algorithms can neutrally and clearly highlight these kinds of discrepancies, what does this mean for the future of global legal accountability? Could AI actually become an impartial monitor for human rights worldwide? It is a fascinating question to consider. Thanks so much for joining us as we unpack this source material today. And as always, keep questioning the world around you.